Hello and welcome everyone. I'm Yash Kesri and I will be introducing you to a specific yet interesting definition, which is jurisprudence as lawyer's extraversion by Julius Stone. Hope you find it interesting. Now let us see that what I will be discussing in this video. I will be discussing only the introductory part of this definition. Okay, so let us begin. Now let us discuss the obvious meaning or what is the interpretation of this. Okay, now Julius Stone interprets this definition as it is a lawyer's examination of the percept, ideas, and techniques of the law in the light derived from the present knowledge in disciplines other than the law. Okay, it is a lawyer who examines every fact, every evidence, and then he only comes to a conclusion. Let us understand the term lawyer and extraversion because it is necessary that before we jump onto the lawyer's extraversion, we should know that what the lawyer means or what the extraversion means. So, let me clarify the meaning of the two terms. Then, according to Merriam-Webster, a lawyer is one whose profession is to conduct lawsuits for clients or to advise as to legal rights and obligations in other matters. Then according to the renowned law dictionaries like Black Law Dictionary and Bouvier's Law Dictionary, lawyer is a person who is learned in the law as an attorney, counsel or solicitor, or a person who is licensed to practice law. Now let us move to the term extraversion. Then according to again we will use the definition of the Merriam-Webster. It says that extraversion is the act or habit of predominantly concerned with and obtaining gratification from what is outside the self. So the word gratification means the pleasure. Now let us come back to the definition, lawyer's extraversion. Now if we combine both the terms, we find that the lawyers as guardians of the law play a vital role in the preservation of our society. The fulfillment of this role requires an understanding by the lawyers, okay, of their relationship with the functional inner legal system. A consequent obligation of lawyers is to maintain the highest standards of ethical conduct. Now, in fulfilling his professional duties, a lawyer must necessarily assume the various rules that require the performance of many difficult tasks. Not every situation while he may encounter can be foreseen, but fundamental ethical principles are always present to guide him. Within the framework of these principles, a lawyer must, with courage and foresight, be able and ready to shape the body of the law to the ever changing relationships of the society. Now, each lawyer must find his own conscience, the touchstone against which to test the extent to which his actions should rise above minimum standards. But in the last analysis, it is the desire for the respect and confidence of the members of his profession and of the society which he serves that should provide to a lawyer the incentive for the highest possible degree of ethical conduct. The possible loss of that respect and confidence is the ultimate sanction. So long as its practitioners are guided by these principles, the law will be continue to be a noble profession. This is its greatness and its strength, which permit of no compromise. Then a lawyer is less concerned with the theoretical field and more interested in the applied field. That is why in the USA there is a practitioner's doctorate, the Juris Doctorate, in the appropriate degree. This is the applied field, while the academic field is the jurisprudence. The jurisprudence that is theoretical or philosophical degree would be a terminal, research oriented jurisprudence science doctor. Okay. Extraversion, now I'm again defining, is the act, state, or habit of being predominantly concerned with and obtaining gratification from what is outside the self. The theoretician is less concerned with how to create a just disposition and more interested in what it takes to define fairness, justice, and associated philosophical components. Therein, therein lies the problem. While a lawyer is a practitioner, which means a technician in the application of the law, the lawyer may not have or require the pure theoretical focus. It would be the theoretician who would be a better defined as a person who has an extraversion of the law. The more common theoretician would be someone like Ronald Dawkins or the H.L.A. Hart. Both are considered as the legal philosophers. People from this approach may have a JD, but they are just likely to hold a PhD, especially one with a heavy theory and research focus. Think of it like a certified auto mechanism and a professional auto engineer. Both work in automotives, but in slightly different ways. Then the mechanic's focus is on making the vehicle operate better. Then the engineer is interested in the design of the part that the mechanic replaces to make the car better. Former is more practice oriented, while the latter is more theoretical. This is it for our video. To follow more on this topic, subscribe to our channel and press the bell icon to stay updated with us. Thank you and see you soon.